could, we'll do the pledge first, and then we'll do a roll call. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And if we could have a roll call, please.
Mayor Jane Castor. Director Frazier.
Here.
Director Hudson.
Here.
Director Johnson.
Here.
Chair Kemp.
Here.
Director Knight.
Here.
Director Myers.
Here.
Director Owen.
Here.
Director Schisler.
Here.
Director Vieira. Here. Director Williams. And Director Woolstle.
Here.
You do have a quorum, Madam Chair.
Thank you. And with that, we have 3 people signed up for public comment. Our public comment is 3 minutes long, and I'll call in order 2 are virtual. Dr. Belinda Noah, virtual. Are we able to bring them up virtually? Okay, we'll call again at the end of this. I'd also like to recognize that Mayor Jane Castor is present. Mauricio Rosas. Okay, and it appears that we have 1 person signed up for in-person, Nephthys Proctor.
Madam Chair, she does not appear to be here either. Director Williams did join the line. I wanted to make you aware of that. But also, we do have 3 people who are physically present as of this morning to provide public comment. The first one is Ishmael Rivera, if he would be recognized.
And I'll just remind everyone again, 3 minutes for public comment.
Good morning, Madam Chair, members of the board, newly elected commissioners, and staff. My name is Ishmael Rivera, and I represent, I'm here on behalf.
Hey, Danielle, we can't hear.
Excuse me, did,
She just turned it on.
okay, thank you.
I'm here on behalf of Amalgamated Transit Union, and I am the trustee, and I'm also here with another coworker of mine. We stand here before you today to just bring a couple of concerns, quite a few concerns that we've been having within the last 5-6 months or so. Right now, the way it stands with all this, I would just say miscommunication scandals or toxic work environment, whatever they want to call it. We have the members out there right now that have there's no guidance, no leadership. No one knows what to do as far as, directors. There were some directors who were terminated or laid off, whatever terms you want to use. Right now, we have no direction. We have employees trying to address issues, go to some managers or even some directors. They don't know what's going on because of what took place within the last couple of weeks. We asked, as the union, that amongst all this scandal that's going on, it's kind of appalling to us that the members, they have no confidence in the leadership as we stand here today. They don't like what's taking place. They don't like the direction that the CEO is going for this agency. And we stand here as the voice of the people. All these nice presentations at the last meeting, we have a mock-up that's being pushed back to March. Nobody's communicating this to the employees. Nobody's communicating this to the union. On-time performance, and a lot of other things. We just put more pressure on the employees. It's hostile. I see it every day. I deal with it every single day. We've tried. We've actually tried to talk to some managers. There's no direction. Everything comes from the top under the leadership of Ms. LeGrand. So there's no confidence, the members have no confidence in this leadership, and we ask that something be done on behalf of the employees that not I hired, but that the agency has hired, and we need to get back to the way we were. It's toxic. It's very bad in the workplace. Sometimes it feels like I'm going to some kind of, county jail or something because there's no direction. Nobody can make a decision unless they speak to her, and that's not a good feeling. So I hope that this board, this body does something about what's going on so that we can just get rid of all the negativity that's going on. And let's serve the people that we got elected to do, and that's serve the public, and that's it. Thank you for the opportunity to let me speak in front of this board today. Thank you.
Thank you.
Thank you.
Madam Chair, are we allowed to ask a question?
Um,
Or do we have to wait for public comment to be finished?
Let's wait for public comment.
The second speaker that I do have signed up this morning is Brenda Moore.
Good morning, board. My name is Brenda Moore. I'm one of the co-trustees here with the union members at HART. Over the past few months, we have developed a relationship with the leadership, with the managers, and it seems like all of a sudden that was ripped from up under us by the firing of those directors. We had been able to work with them, come in and sit down, even though it's been a shaky year. I've been here for almost a year working with these employees, and it just seems that we have no direction. The community needs an organization that can help, that they can count on to get back and forth from where they are going. And with poor leadership, then we feel that we can't service them because we're not being serviced. The members are not being serviced. The employees are not being serviced. Ms. LeGrand, I don't have anything personal against Ms. LeGrand, but the work relationship seems to be very hostile there. Just coming in, you can see the hostility. And I think that the members of ATU, the workers of HART, deserve better. And they deserve to be treated right and deserve to be able to come to work and feel that it is not going to be a hostile work environment, and that's what has happened. So ATU is just requesting that you guys take a look at the leadership that we have with Ms. LeGrand at the helm and do something about getting a more stable environment for these employees as they are working day to day, transporting the community. Thank you.
Thank you.
The final person I have signed up is Steve Simon, but my understanding is there may be others after Mr. Simon who would like to also speak.
Good morning, everyone. How you doing? Steve Simon, president of ATU Local 1464 in the city of Tampa, and I'm here in support of the employees, ATU 1593 members in the community, and we are looking for new leadership due to the troubled leadership that we have currently, and I'm here to support them in regards to that. And so we hope that you do the right thing and support what we're looking for. Thank you.
Thank you. Are there any, I guess at this time, we'll entertain public comment from anyone else? Okay.
I'm here.
Oh, who is this online?
My name is Tom Rask.
Okay. I don't know about, okay, that was not pre-signed online, but go ahead. Well, I thought it was one of the people we missed online. Is there anyone else online? Okay, we'll take that, and then we'll go to Ms. Lewis.
So do it, go ahead?
Yes. Can you state your name again?
Okay. My name is Tom Rask. I live in Pinellas County. I don't, you said that it wasn't pre-signed up, but as I wrote to Ms. Jackson, there's nothing in the board rules that say that you have to sign up by the day before. I reviewed paragraph 210, subsection 4 of the formal board HART policies. And I mentioned that in part because I wanted to segue into that you are now considering firing the CEO in a meeting which is properly noticed, which wasn't the case in February 2020 when you fired Mr. Limmer. In that case, you only gave 4 days notice of your meeting, even though your board policy calls for 7 days. I don't pretend to know all the ins and outs of this matter or what's going on behind the scenes and what prompted the union to release this statement to the Times yesterday late ahead of this meeting. I'm sure that's why the article was written, because, well, they wanted the publicity. But I'm calling to support releasing, firing, terminating, whatever you want to call Ms. LeGrand. I suspect you're going to find a lot more bodies buried, so to speak, once she leaves. There's signs of serious problems, but the board is also at fault for this. I've commented on this in the past. The board or the board of any public agency where tax dollars are involved are there to oversee the workings of that agency. However, this board, it's not alone, instead overlooks the work of the CEO and the agency. This will be, you've had a revolving door, one could say, of CEOs here over the last few years. HART is a failure. You should look at contracting out any services to provide those who need mobility the most. That would be the most cost-effective, best way to do this. So while I support terminating Ms. LeGrand, you need to dig deeper. There will be more bad news coming out about HART, I'm sure of that. And thank you for your time.
Thank you. And just for the record, so there's no misunderstanding, the meeting with Mr. Limmer, when that came up, was a regularly scheduled board meeting, actually, with a whistleblower complaint 3 days before. So
That's not true, but go.
excuse me, your time is up. So with that, we're going to recognize in the room Ms. Lewis.
Good morning, Board. My name is Yvette Lewis, and I am the president of the NAACP Hillsborough County Branch. I come to you to stand before because our office have received numerous of calls, numerous of emails. Some of them disclose their name and some of them anonymous. And regarding the complaints on how they're, from the employees on how they're being treated at HART. And I'm trying to work with them to help them get the resolve. And sometimes it's just, it's not going in the right direction. There is a lot of issues, a lot of concerns going on at HART at this present time. But those issues were there before Ms. LeGrand got there. I want you to know that. Those issues are not oblivious to the community, but the staff morale is going down lower and lower, and something has got to give. I come to you to ask the board to really find a resolution about the staff. That staff goes out into the community and they're part of our community. If you got someone who has all this trouble on their mind and they're driving that bus, that's not a good fit. So I need you to help me help the people that's contacting our office because they need someone to mitigate, understand conflict resolution, what they're going through. But I really want you to understand this. This didn't just start. This problem has been here, and it's up to this board to get it resolved. Thank you.
Thank you. And is that the end of public comment? Do we have anyone else at this time? Okay. We'll proceed then with the meeting at this time. I'm sorry, Ms. Director Frazier, you had a question?
I did have a question just for Mr. Rivera. He didn't state, but I was just asking how long he's been with HART, how long he's been working for HART.
Ma'am, I do not work for HART, I work for the union.
Okay, you're not a HART
I
employee.
work for the International.
Okay, thank you.
Thank you. Okay. And with that, I'll just proceed. It's important that we realize that the meeting is limited to the authorization of an investigation consistent with the issues described in the special meeting notice. And we need to take action while we have a quorum at this time. On that basis, I'd like to have General Counsel David Smith provide us with a summary of exactly what we need to do and how we need to respond from here.
Good morning, Madam Chair and board members. David Smith, General Counsel for HART. I want to reiterate that this is a special meeting and it's pursuant to your policy 21003. And what that means is, unlike public comment, our actions here today are constrained. When the public comments, we let them comment on what they will comment upon. But today we are here for a limited purpose, and is the purpose specifically described in this notice of the special meeting. And I will remind you that under 210.03.5, quote, no business shall be transacted at such special meeting save that specified in the notice. So we're limited to the issue that is before you, and that issue is to authorize outside Labor and Employment Council to undertake an investigation into the topics described in the notice of special meeting. We're not here to evaluate the CEO. We're not here to hire or fire the CEO. If that is to be a discussion, it will occur December 5th or thereafter. We are here simply for the purpose of beginning and authorizing an investigation. I would like to caution the board members that this is an issue that has various legal considerations involved. So it's important that we speak carefully, and what I often say to my clients is sometimes speaking less is better than speaking more. It is important that you realize you will be the quasi-judicial body that will hear the facts of the investigation and will make a determination as to what is to occur, both specifically in terms of the person who is subject to the investigation and as a legislative body in terms of the policies you think need to change in order to address the issues that are discovered. But part of that is quasi-judicial. You cannot be or appear to prejudge an issue. So I'd caution you, it's important to make sure you get the facts before you make any statements and let the process unfold. Those of you who are lawyers, probably half of you, understand that the biggest problem that can occur to a public agency is not to afford due process to people who appear before it. You can be substantively right, but if you get to due process wrong, you lose. So we need to be careful. Consider yourself a judge, because that's what you are. Having said that, I would like you to understand I also spoke with David Adams. He's been a outside labor and employment counsel for HART for many years, probably as long as I have been general counsel. And he is an excellent attorney. He understands the process. One of the things I want to make sure you understand is that this will be an independent investigation. David Adams is outside counsel. He's not hired and fired by the CEO. He is hired by the board pursuant to a procurement process. He is ultimately accountable to the board, as are all attorneys who work for HART. The Florida Bar Integration Rule requires that an attorney owes an obligation to the governance body. That is you. So that is what Mr. Adams' obligation is. That's my obligation, Ms. Bailey's obligation, and we will live up to that. In order to make sure that is independent, what we're going to have is David Adams will report directly to the general counsel in order to report directly to the board. There will be no one who is hired and fired or controlled by the CEO that will be involved in that process. So this will be an independent and a fair investigation, and you can be confident that that's the case.
Chair, point of order. We're here today, to my understanding, to determine whom and what methods the outside counsel should be. But what we're hearing right now is that outside counsel has evidently already been chosen, and we're speaking as it's in the past tense. So I'd like some clarification.
No, this board will be choosing that outside counsel or any other outside counsel. That decision's not been made. It's, at this point, just we investigated, and I can let...
Sure. Let me clarify. Basically, your outside counsel is retained pursuant to a procurement process. You only have 2 outside labor employment attorneys. You have Cindy Townsend, who's with the Bell Roper firm in Orlando. I talked to her to see if she was available. She is not. So I did not bring to you today both lawyers, because one of them won't do it. She's unable to do it. So the only person left for us is David Adams. You could go through a procurement process, but I'll tell you that process takes multiple months, 2 to 3 months. So my recommendation is, as your general counsel, that you go with David Adams. It is your call. You will be making that authorization, and that's why I wanted to make sure you made that authorization, so we make it clear that this is an independent investigation. I would also, one last thing I would say, I would suggest you put some kind of a time limit on this process, simply because the last time this occurred, it unfortunately went on interminably. I think we were 7, 8, 9 months. That's not fair to anybody. So I'd recommend you consider a 60-day time limit, and hopefully, if there's any issues, the board can always decide to extend that if necessary. But I think it's good to have a target so things get done quickly, and maybe prior to that if possible. That's essentially my presentation. If there's any questions, I'd be happy to try to answer them.
Thank you. Are there any questions?
I have a question. Is Mr. Adams here?
He is not.
I have a question.
You're recognized.
Chair, is it not the exact procedures of the Florida's Inspector General to handle such investigations into these exact type of issues? And would it not also save HART money?
And maybe we can have counsel respond to that.
My understanding of the Inspector General is somewhat limited, but my understanding is it primarily deals with fiscal irresponsibility and problems of that nature. We do not know yet whether we have that problem. That's not to say we don't, but this would be an investigation that could lead to that. But we need to have enough information to trigger the jurisdiction of the Inspector General, as I understand it, and that just doesn't exist yet. And I'm not prejudging the issue. It just doesn't exist yet.
Thank you.
You're welcome.
Any other questions at this time? Okay. Mr. Knight.
Okay. Good
Director
morning.
Knight.
I'd like to make a motion that we move forward on an independent investigation, also along the lines as doing a temporary replacement until the outcome, so everybody can feel comfortable, the workers and everyone, and I'd like for my other directors to chime in on it.
Okay, we have a motion, and can we put that in 2 parts? Would you mind, so we could move forward? We have a motion both for an investigation to approve offering this to David Adams, an outside labor and employment counsel that was recommended by Mr. Smith. So we have that motion, and do we have a second? And then we can talk about the suspension after that. Okay, motion second. Is there discussion with regards to that?
Yes, I'm in support of using David Adams, but I do think we need to have a discussion about the scope of the investigation.
Okay.
But that doesn't seem to be a part of the motion. So is that a separate motion, or is that?
We had talked about this before, but I'll tell you, what we'll do is we'll approve this, we'll go to the scope, and we'll talk about the scope, and then further we can talk about suspension after that. So with that, this was the dual motion made by 2 topics made by Mr. Knight. That's why I say that.
And that's why I wanted to just, as far as, I don't know if Mr. Knight would, or Director Knight would like to kind of withdraw that motion and kind of clear up the fact that there are two motions, I think, kind of in that statement, because it seemed like it was a combination of things. I
It
certainly
seemed
don't-
okay when I
Not a
asked,
problem.
but,
You can do it two if you want it done.
okay. So Director Knight, what we have here is a motion by you to approve the retention of David Adams as outside labor and employment counsel for this investigation, which I think it would be helpful to put 60 days in there as also with regards to this. So we have a motion by Director Knight. Do we have a second?
Second.
I think we had a second before, and sorry. So we have a motion and a second, and we had some discussion. We'll put off the other parts of that till after, but do we have any further discussion with regards to this motion on the floor right now? Okay, seeing none, we're going to take a roll call vote if we could.
Chair Kemp,
Yes.
Director Williams,
Yes.
Director Castor,
Yes.
Director Frazier,
Yes.
Director Hudson,
Yes.
Director Johnson,
Yes.
Director Knight,
Yes.
Director Myers.
Yes.
Director Owen,
Yes.
Director Schisler,
Yes.
Director Vieira.
Yes.
Director Woolsel.
Yes.
The motion passes unanimously. Thank you, Chair.
Thank you. And we'll take up this, what I would consider maybe the second portion of this, which is the scope.
Madam Chairman, if I might, I'm a little concerned that this issue was not clearly articulated in the notice of the special meeting. It's not to say it's an inappropriate action. Clearly, it can be an appropriate action. I'm just not entirely sure and not comfortable whether this meeting has the authority to do that. It may be you need to defer that 1 week to the December 5th meeting of the full board. The rule could be clearer, but it's because it's unclear, and I'm uncertain whether it's within the scope of your meeting today. I'm a little concerned about the board taking that up.
Well, right now,
Point of order real quick, because I would agree that if we could suspend, then we could also terminate, if we can take any action. So, I guess that, I would like that clarification. If we have the right to suspend somebody, would we have the right to terminate?
That's why I don't think you have the right today to suspend, because I don't think you have the right today to terminate. It should have been in the notice. So, but the board will meet in a week, fortunately. So it is clearly, I'm sorry to speak to policy, an important policy issue that this board needs to decide. I don't know that we even have anybody in mind that could possibly serve in an interim capacity. So I would suggest that we not take that up today, that be taken up at the full board meeting where you have clear and appropriate jurisdiction to do so. Because again, if we're in a litigation context and if you do something that is ambiguous in terms of your authority to do so, we are at risk. Of course, we lawyers always like to protect the client against risk.
so to be clear,
Yes.
right now,
My advice is not to move forward with
so
the second motion.
simply to move forward with passing with the investigation, we've approved that, and to agenda in 1 week, to agenda the scope of this investigation.
No, I think the scope is determined by virtue of the special notice. And the special notice specifically indicates it deals with the allegations of a hostile work environment, various hirings and firings, terminations, if you will, including but not limited to Terry Wright. I think that is the scope of the investigation this board wishes to have. I will also caution you that when an attorney undertakes an investigation for a client, they're obligated to report anything they find to that client. So as much as we want to have a clear scope, and I think we have such, he may find things we don't know anything about, and he's going to be obligated to bring that back to us. But in terms of his focus, it's the issues that have been described in the special notice. So that is the scope of his investigation.
And can you just, for the record, read, do you have it right there, the notice?
I don't have it right here, but I can get it.
I think it would be helpful, because
Thank you.
not everybody has a copy of it. I think it would be helpful for everyone to hear what that special notice says in terms of this scope.
Okay, the notice must identify the place and the time, so it's done that. The purpose of the meeting is the third item. The purpose of the meeting is to discuss the recent communications received by board members pertaining to workplace practices of the CEO, related press coverage of various employment issues, and attendant hiring and termination of employees, including but not limited to the dual employment of Terry Wright. The purpose will also include the determination as to whether or what type of investigation is required to be authorized. That's the scope right there. So
Okay. So, and as well, I think it would be good to clarify, you said it before, but I think it'd be good to clarify so everyone can hear that. We heard the scope just now. But as you said, anything found in the course of this investigation also, it can be relevant to further, for looking at it, if they found an issue that wasn't clearly.
Has an obligation to report to his client anything that he or she finds in the course of investigation or representation that needs to be brought to the attention of the client, which in this case is the board. So yes, if there's something out there we know nothing about and Mr. Adams finds it, we're going to hear about it. So you define the scope, but in a sense, because of the rules regulating the Florida bar, you can't really limit it.
A point of order real quick. So, and I am looking at this as a lawyer, so forgive me, I'm new, and I'm fresh out of litigation here. And when I look at this notice, it says the purpose of this meeting is to discuss the recent communications. It sounds like this body's supposed to discuss all these matters here today, but yet what you just kind of described is to be careful what we discuss today, because that could cause a problem in the investigation or ultimately in litigation. So I guess my question is, then this notice to me looks a bit defective, because it's kind of looks like to me it's an open forum for us to ask questions, is the way I look at it.
And I hear what you say, and that was unfortunate, because it was intended to be to identify those issues leading to the action you were going to take, which was an investigation. Could have been more artfully drafted. I'll talk to the person who drafted it.
Yeah, well, it just puts especially new people in a little disadvantage, because we haven't been on this board. So, you know, in a way, I'm looking forward today to asking some questions. Not anything that's like a deposition or anything, but to asking some questions. But then on the flip side, I want to be very careful of what comes out and gets fleshed out today.
Yeah, and that was unfortunate that it was worded in that fashion, particularly because of the litigation risk we have. It's best that we not have that full scope discussion. It's best that we launch the investigation, get the facts, and then have the discussion. And you'll have the discussion next week about what's appropriate in terms of interim leadership.
Yeah, because there's a lot of litigation just in this paragraph that you can see that you can pick apart. So.
Oh, yeah.
I have a question, Madam Chair.
Go
for
ahead,
David.
Director Rena Frazier.
Using this special meeting notice, I think, as the scope, it feels a little overbroad to me. If we're paying an attorney to do this investigation, for example, it references related press coverage of employment issues, and I mean, that's just a small example. We don't need an attorney to look at press coverage of issues, and so that feels very overbroad.
Yeah, that was intended to be a nominative to basically identify the nature of the activity, which was the Terry Wright issue. So it was to describe that rather than, certainly we're not looking into the press. We have First Amendment issues that pertain to that. So on a common sense understanding of this, it's really to look into the complaints that have been discussed in the press, not to discuss the press's coverage of it.
It also feels overbroad just to say complaints discussed in the press. What complaints are we talking about?
Well,
do you know what I mean? I'm just saying it just feels very unlimited in scope, actually.
Well, I think the intent was to have the complaints that were delivered to this board that have been discussed in the press. So it's not, there's two modifiers to describe the nature of the complaints. Those that have been received by the board, which have been discussed in the press. So we could have left which have been discussed in the press out, if you would like. But I think because it's also a meeting in which we notice the public, it was intended to let them know that the very issues they have been reading about will be looked into.
Chair, parliamentary inquiry.
Yes, I'm not sure who asked that.
That was me,
I'm
Chair.
sorry. Go ahead.
I hate to ask the obvious question, but it says we're here to discuss workplace practices of the CEO. The CEO is here actually with us today, and I'm not sure if she's even going to be given an opportunity to speak, but is it safe to simply ask the CEO's willingness to spare all of this and her willingness to resign?
You're certainly free to ask that.
I guess that question has been made,
She's not required to answer, but he's allowed to ask that.
of course. Okay.
After.
Yes, okay, we have Director Vieira.
Thank you very much, Madam Chair. You know, a couple of things. I think it's incumbent on us. The notice is what it is. If the notice needs a haircut and we got to define in terms of what the investigation is going to be about, if the investigation moves forward, I know that, that a question was just asked that could curtail that, but if it moves forward, I think we have to define what's going to be in that investigation. I think there are some open and obvious issues we should agree on, which is number one, the issue of double employment. And what the director knew. There have been certain statements that are made in public. We want to make sure that those public statements have strict fidelity to what the attorney, Mr. Adams, will ultimately find. Number two is obviously workplace issues, respect for people on the job who work for HART. I know we all share the sentiments that we appreciate those individuals who came to work for HART and who represent the hardworking employees of HART in speaking publicly, because that takes a lot of courage, and we want to make sure that we highlight that as part of the investigation if it moves forward. So I think those two issues. Another issue, which I can inquire into Monday, is what remedies this board has in terms of the allegation of double dipping. Can we get that money back to be good stewards of taxpayer money? Maybe not necessarily for today, but we can inquire into that, et cetera. The issue that Board Member Knight brought up, I think, is a very good one in terms of potentially, again, looking at suspending the director in the meanwhile. I have to ask some questions on the next few days, so the fact that we don't look at that until next week, for me, is actually beneficial, because I think that's something with some potential there, but I wish to make inquiries on it outside of this meeting. So I think highlighting those two issues today is, I think, good. And I think we should start there just to get the ship sailing forward. Thank you.
Madam Chair, if I could clarify.
Yes.
I'll try one last time to clarify. Essentially, the notice is divided in two parts. I'd consider the first part to be a predicate fact. I do not know what this board has read. I know that complaints have been sent to, primarily they were sent to the county commissioners and not necessarily to this board. So the point of that was to try to identify the issues. So the discussion is about the issues. The action is whether or not to take an investigation. And I think the action is, and I think the motion made by Mr. Knight is, to authorize the investigation, to look into the allegations that have been made regarding a hostile work environment, and to look into the allegations that have been made regarding Terry Wright. I think that's the clear scope of what this board is doing today, irrespective of how the notice was worded. Because I would take that first part of the notice, again, as you know, I frequently have to deal with folks who haven't had an opportunity to review the agenda, let alone all the complaints. I haven't read all the complaints. Most of them went to Julia. But I just wanted to have the discussion to get out there the nature of the issues that need to be addressed, and then for the board to take the action to authorize the investigation into those issues, including Ms. Wright, and to come back to this board with the information it finds. So I think that's the scope as it exists, and I think that hopefully makes it clear enough that that's what we're doing and what we're recommending to be done.
Okay, Director Myers.
Yeah, thank you, Madam Chair. To the legal counsel, thank you for your comments, but one clarification. Would you be with us throughout the process, that you would be in the meeting? Because we meet next week on the 5th, and to make sure that we have all of the information, because you said earlier someone else wrote the recent communication pertaining to the workplace practice, so that we get it right. So when we come to the December 5th meeting and we are preparing to vote, we don't have something someone else did, or it wasn't written correctly, or it could have been changed. So I'd like to know, going forward, will you be in the meeting, or will it be Ms. Mandel, so that the questions we're asking, we're not having from two councils?
I will be at the meeting December 5th. But I want to make sure we're clear, though. The action taken today by this special meeting is to start the investigation. So
I understand that.
But yeah, and then the other issues that follow from that, December 5th, whether there's a suspension, whatever, I'll be there for those discussions. Yes, ma'am. And I'd recommend Mr. Adams be there for those discussions.
Yes.
Because he's the Labor and Employment Council.
Yes, I do agree with that. Because this notice for today's meeting had the 7 days where we could have had all of the clear information, whether we was going to vote to notice the public, whatever action was going to take today. We had the 7 days prior to this meeting called for today. Am I correct?
We could have included in the notice, if it was so intended, that you could address the issue of suspension as well today, but it was not. That's why I'm recommending you address that on the 5th.
And that falls within legal counsel to bring to us, because you all discussed along with the chair all of the actions that we anticipated on wanting to take for the special meeting today.
I'm not sure I understand your question, but we will definitely be there next week to discuss what your options are in terms of suspension with pay, termination, whatever it is you want, or non-termination or non-suspension. But you need to have someone who's going to step up into the leadership position. And the discussion, to the extent it was held prior to this meeting, was that's an unknown. So that was not put on this agenda for that reason, and so it's therefore not within the scope of this meeting.
I get that. But my question is, for today's meeting, the public, along with the board members, could have been notified of the action that we came to this meeting for today, within the 7 days.
And which actions are they?
If we wanted to fire the CEO,
Yes.
if we wanted to have the investigation, all of that could have been in the,
Yes.
printed in the notice for today
Yes.
for us to take action.
If that was the direction by the person calling the special meeting, which was the chair pursuant to consultation with me. So we did not do that for the reasons I just discussed. We don't have anybody we would recommend that would step up. So that was not specifically noticed because it wasn't considered to be ripe for discussion.
Okay, thank you.
You're welcome.
Madam Chair, if I may, real quick. In the scope of the investigation, just to be clear, is it just looking into Ms. LeGrand's conduct, or will we also be looking into Terry Wright and possible claims against him or her? Are we going to be looking into that? Because I can tell you a lot of times if the first to the trough in a lawsuit is who gets paid. So if New Orleans is doing the same thing, I think that investigation should include his conduct and possible claims against him as well. Her.
Yes,
Excuse
it
me.
will.
Will. Good.
Okay, and seeing, no, I'm sorry. Mayor Castor.
One, thank you for clarifying the discussion and the reason that we're here. And the reason that we're here is to get information, specifically facts. And so I think that a lot of this discussion has gotten way in front of the reason that we're here. And I've been involved in a lot of investigations in my lifetime, and we have to deal with the facts. And if there were policy violations and the potential of legal violations. So the talk of suspension, termination, we don't even have the information yet. We don't have the facts. And we brought Ms. LeGrand in to try to change the culture and lift up HART as an organization, a very underfunded organization that serves our community. So we need to be very clear in what this investigation is going to include and then make decisions based on the information that is brought forward through that investigation. And also, I just want to underscore that we are here as a board, again, to ensure that we are providing a great service, the best service that we can to our community. And we need to stay focused on that, as does the organization of HART. A lot of great people out there serving our community every single day. We need to make sure that we are supporting them, we are supporting this organization, and not get distracted or detracted by this investigation or these occurrences. The information is going to come out. Let's all wait until we get that information before we make decisions. Thank you.
Thank you. And do you have, no? Yes. Director Hudson.
Regarding some of the anonymous complaints we've received, is there a chance that any of those would, I guess, constitute a whistleblower claim that would become separate from this investigation that Mr. Adams is going to be pursuing? Or, I guess, if those are a concern that board members have, should those be explicitly put into the, what we'll call the Adams investigation? Or is there a chance that those would, just by virtue of what was stated in those anonymous claims, would on their own become like a whistleblower complaint that would proceed separately?
That was my first question. When I was advised of the complaints that were made, I called outside Labor and Employment Council. I do real estate, land use, and local government. I know that you use lawyers who specialize in what they do. I don't litigate. So I called Labor and Employment Council, and I said, I'm concerned that this communication is in the nature of or is a whistleblower complaint, because if it is, we need to proceed in a different fashion. And she advised me that it is not. It is a public record by virtue of the way it was presented. So the person who wrote it chose to not invoke protections of a whistleblower, which they could have had they phrased it and worded it differently. So to this point, I have no knowledge of any whistleblower complaint. If we get one, it'll have to go through a separate process.
Okay, I think Director Myers.
Thank you, Madam Chair. Since we are talking about Ms. LeGrand, Council, is it okay if she wishes to speak, or would it be at the December 5th meeting so that we could hear from her or what she might want to say to this board?
She is certainly free to speak. No one has lost their First Amendment rights, and she can speak if she wishes, or she could wait till the December 5th board if she wishes.
Ms. LeGrand.
Director Williams' hand is raised. Do you
Oh, thank you. Okay. Director Williams?
All right, thank you, Madam Chair. My question is centered around, I understand the process, and we will go through the process and let the process work. My question is centered around those individuals that have been offered, that have, I guess, given a package, and we are in the midst of them coming off of payroll, but have not yet come up, but are still waiting their package. Is there something we are doing with those individuals since they're right in the middle point of the process? It's my understanding
Thank you. I think what you're saying is people that were, are you saying people that were notified that they were in the last week?
They were notified, and yet they are be paid until a certain period of time into next year. So I'm just asking questions, is there something that needs to be done at this point, or is their process going to continue as it is today?
Madam Chair,
And they would.
I'm going to let counsel speak to that for.
Madam Chair, I would suggest that that is another topic that should be taken up at the December 5th meeting. I do not believe that's within the scope of the notice for today.
Okay, well, I just wanted to bring attention to the matter that it needs to be a part of a discussion because they may be midway through the process, and I'm not sure if it is a point of discussion for us to evaluate, or if they just continue to go through the process at this point.
Thank you.
Does that
Yes, so you're talking about the, I don't know how many people it affects, but people that are in process of, they had been noticed that they are no longer employed by HART, but at this time they're an off-boarding process, I guess, of sorts. So you're talking about those individuals and their status. Correct?
Right.
Okay.
Right.
So we can just put that on December 5th. And at the December 5th meeting, I think we can, if I'm hearing what everyone here has said, we will move forward with investigation. We've discussed the scope of that investigation. It may be, it's broad, but it will take, there was some suggestions that it was too narrow, others that it may have been overly broad, but I think we maybe have some clarification about how we proceed forward in terms of the scope. Yes, Director Hudson.
Sorry, one more question, David, about that scope.
Thank you.
In your legal opinion, do you think there's adequate definition about what the scope is, or should we have a motion to tighten it up a bit? Because I'm willing to give that a shot. What do you think as our attorney?
I think in light of the clarifications and the colloquy that has occurred with the board and council, I think we all have a pretty basic understanding of what we're doing and what we're investigating. If someone has a different opinion, then we can have further discussion on that. But I think we understand we're looking into the issues that relate to and involve or revolve around hostile work environment. We're looking into terminations and hirings, including dual employment, and tracing that to its sources. And I think that's the scope of the investigation.
Any other comments at this time? Go ahead, Director
Thank you.
Knight.
One of my concerns is, excuse me, is some of the ones who have received severance package. You have a date on that, a time limit. With all this going on and also all uncertainties, will that be postponed some, delayed, or give more extension? Or what's going to happen to some of the ones that possibly with the severance package that could perhaps stay? The workers and everything, we need some type of safeguard in place. And maybe you can help us out on this, on what we can do where leave this meeting, because it happened before. And when we left the meeting, that same day on the board meeting, there were some other firings or other things going on. I want to know, how can we stop whatever now? That's why I brought up as far as bringing someone else in there, in here for the time. Till we work out everything, so you, somehow, if you can work on that some.
We would be happy to look into that. I would want to make sure I'm clear on it, however, that we had no involvement in negotiating any of the separations, negotiating any of the packages. We do not have the legal background as to what transpired, what risks there might be for unwrapping that. That's why that would be best taken up December 5th and beyond. I don't know whether outside employment counsel was used for that. We were certainly not involved in that discussion. So I understand your point. It's an important point for this board to address, and we'll find out what we can in the interim to give the board the information it needs to decide what to do. I would just caution you, there's potential legal issues associated with that. From my understanding, there's NDA agreements in it. I only heard that in the press. So it's a complicated matter. That's why it's, I don't think, appropriate to handle today, nor is it properly noticed. But I understand what you're saying, and we'll see what we can do to get you the information for the December 5th meeting. You, meaning the board.
If I may, real quick.
We have Director Schisler.
Thank you, Madam Chair. Hope everybody can hear me. My voice is a little messed up. I'm not an attorney. We're beating this to death. I think we've hit every permutation that we could on what we're going to do, what we should do, what we can't do, what we have to do, what we need to do. I think it's time we passed the resolution to call in the attorney to do the investigation. Let's leave it at that for now. We have another meeting on the 5th. If there's anything that needs to be done in the interim, janitorial-wise, we could take care of it at that point. In the meantime, let the attorney, let the investigation proceed, find out what they must, and they can report back to us when it's done, so that we can do the right thing and not judge an entire tenure of someone's, or the entirety of someone's tenure based upon an incident that has been dealt with. So let's let the investigation play out and move forward from there. We're just beating it to death. Thank you. I'm sorry.
And before we go on, I'd just like to say everyone has gotten to speak, some people multiple times. I wanted to make sure that everyone had an opportunity. I think we've heard from some instances of, things that we maybe didn't have on our agenda for the 5th, which would be things like those that are in, have severance packages now, and at least a consideration of that. We did approve an investigation going forward. It sounds like we have a scope that is agreeable to everyone here in terms of its all the issues that it will look at. So the one thing that we didn't get to were these employees that were, the severances that were done. That can be part of the investigation, but also it sounds as though there is a need to look at that more closely within the next week before the December 5th meeting. As well, there was discussions of suspension, and those at this time, one of the things we wanted to do is quickly get to that we were going to look at this and get an outside counsel for this. We have a meeting scheduled in 1 week, and at that time, we can look at some of the issues that were raised during the week here in terms of those employees that have severance packages now, but were just recently fired, since that was raised by at least two directors at this board, as well as looking forward on the December 5th. We will have this on the top of the agenda, first thing, and we can, at that time, discuss. I know there were some calling for immediate firing. I think we have due process issues with that, and that was the sentiment pretty much, I would believe, moving forward with this board. But certainly a suspension or some other, that avenue is, I think, one that we can discuss on December 5th. We have 1 week to go before that, and we can get that worked out as well. But I think we've done good work here with the investigation beginning with the scope. We have, it looks like, agreement here. So we'll put on the first item on the December 5th agenda, we'll be looking at the various questions that were raised here and discussion that went here for December 5th. And we'll put that on the agenda, and we can have that discussion then. Is that? Yes, go ahead, Ms. LeGrand.
Okay. Thank you, Madam Chair. Good morning, board. Good morning, staff and audience. I appreciate this opportunity to speak. I know today has been a very robust and difficult conversation for all of us. I was hired by most of you to help HART move to another direction. I was hired during a pandemic, which was a difficult time for all of us, not just the organization, but the country, the world. And I came here to find a way, excuse me, to find a way to bring stability to an organization that had been riddled with decades and in the near years of turmoil that have plagued this organization. From 2018 to the date that you decided and voted to hire me as your CEO, you had 6 CEOs serving as the leader of this organization. There's a lot that needed to be changed. There was a lot that needed to be addressed. And I understood when I accepted this opportunity that it would be hard work. Change is hard. It's difficult. And once you make it clear that the expectations are for everyone to work hard, to everyone to be held accountable, to make it clear that we are here to serve the community, that we respect the community, and we respect the fact that many of our customers have no other way to move around Hillsborough County. I also know that having integrity and trust, not only from you as the board, not only from my immediate staff members on the executive team, not only from the leadership team, but from the employees in the organization. I can attest to this. That is important to me. As I was preparing for this meeting, I went back and I looked at my notes. Over the last 8 months, I have had over 30 face-to-face engagements with the staff. In many cases, I've had 3 shifts of engagements with the operations and maintenance team. Not just to say, hello, I'm Adelie, nice to meet you, but to hear from you. Through those processes, we were able to identify opportunities to bring some immediate improvements to the workforce. They shared with us that they wanted improvements to the driver's lounge, to some of the amenities that we had. Also some bigger ticket items that we could not fund in this budget cycle. But it's still on the list, and they saw that their voices were heard. They wrote the information on Post-its, and when we came back the following month, they got to see where their ideas and suggestions fell in our plan. I said at the last meeting that I welcomed this investigation. I do think it's important that the board leads the investigation, I know you are all aware that I was also looking at our own investigation over the last 2 weeks, working with our internal counsel, and we look to hire external counsel to help us do the same thing. We understand that some policies were broken, and it's not acceptable. We recognize that we have to find a way to make those improvements, and that's what we're working on doing. But the work that we have to do as it relates to providing better service to the community, that does not stop. We still are driving buses right now. We're still fixing buses right now. We're still trying to find a way to plug the gap in our budget right now. What I'll say is that, moving forward, my hope is that this investigation will help us to identify areas where we can make immediate improvements, also areas where maybe we have to make some longer-term improvements. But in its essence, it will help us move forward as an organization. I'll also say that even though this is a tough time, specifically for me, and I know that many of you, this is not a fun meeting for you as well, and I recognize that, but this is important work. But I do want to acknowledge that we have made some significant strides over the last 2 years. We were able to secure $75 million for a heavy maintenance facility that's been underfunded and in disrepair for over a decade. We were able to build a financial model, a 30-year financial model, an organization that has 800 people, that has a budget of over $100 million, did not have a financial model that we could use to plan and understand the implications of our funding shortfalls. That's something we have in hand now. We have a 5-year capital plan, so we know year over year how we need to spend our capital dollars. These are all things that the team that we have today worked to accomplish. It's not me doing it by myself, it's the team working collaboratively to make this happen. I will land on this. Someone mentioned earlier that there's a lot of stress associated with on-time performance. Being on time and knowing you can depend on your bus to show up when the schedule says it's to show up is at a minimum the most important thing that I should be doing as the CEO here. If we have service that nobody can depend on, and the fact that I'm asking people to focus on ensuring that we improve our on-time performance, and that we constantly track it to ensure that we are providing reliable service to the community. If that is something that is offensive and off-putting, well, then I say I take full responsibility for making people feel that way, because that's the business that we're in. Our service is not the best service that a community should have. 20 of our routes, we have 30 routes, 20 of them have 60-minute frequencies. And it should be acceptable that people should not expect their bus to show up on time. And as a leader in an organization that's primarily a bus company, my expectation should not be that my leadership is driving the fact that being reliable is important. If that's inappropriate, I accept that. But that's what we're working to do. The work doesn't stop. I understand you have decisions to make, and I respect those. But the team, many of them are in the room now, they understand what the expectations are. And the expectations are to deliver the best quality service that we can provide and to achieve our vision, which is to become the highest customer-ranked mobility provider in the Tampa Bay region. We will continue to work to strive to do that. I've always said that if there's something that you or anyone can bring that will make us better, that will bring improvements, I welcome it. And if this investigation allows us to do that, I welcome that as well. I thank you for the opportunity to speak, and I appreciate the time.
Thank you, and I do think, especially for the newest members, that welcome to your first meeting. And maybe sorry that we didn't introduce you at the beginning. We'll do that in December 5th. But would you just like to give your names for just a second?
Sure. Real quick, Michael Owen, and really looking forward to serving on this board and helping HART become the best transportation in the state of Florida. So thank you.
Thank you. And Director Wastel?
I'm Joshua Wolstel, and I also look forward to helping HART improve its ways. Thank you.
Yeah, sorry that wasn't at the beginning. But at any rate, for the newest members, I think it's really important, and the public, to understand that even though we have this issue before us in this investigation, that our service continues. And it's been, I've been very proud of actually in terms of the service that we have done for the last year in making sure that we had on-time buses, that we had buses, and that we were moving forward with that and other issues like that heavy maintenance facility out there. So I just want to assure the public that service is doing very, very well for what is one of the most underfunded transit agencies in the nation, bar none, not by a little bit, but by a huge amount. So with that, we'll hold this meeting adjourned. We'll meet on December 5th.
Thank you.